friends, good evening to all. This is Advocate Drishti, and today we will be learning about the legal drafting. What are the perspectives of legal drafting, why we are studying this legal drafting, and what are its implications, right? So starting with the video, please stay tuned and keep watching till the end if you want to get the clear concept of drafting, right? So we'll be starting with the video with the meaning of drafting. What exactly is drafting? We are saying that we need to understand the drafting. What do you mean by drafting? The term drafting, as you all know, as you all can see on the board, the word drafting is written. What exactly is drafting? Drafting means a rough draft that we are preparing, a temporary form of written document that we are preparing with the replication of ideas, thoughts in a connection, in a connectivity that form a chain of transaction, right? Like we have read res geste in Indian Evidence Act. As you all know, section 6 of Indian Evidence Act states about res geste. So there should be a connectivity between the facts. There should be a series between the facts. So if there is a series, if there is a connectivity between the facts, then it would be relevant. So drafting also means the same. When there is a connectivity between the paragraphs, when there is a formulation of drafts, and if the formulation is right, and if their omission is rectified, right, so it forms the fair draft. Then omissions are rectified and it would form a basic fair draft, right? So having understood what is drafting and draft, now what is exactly legal drafting? When we prepare a legal document, we need to understand and we need to adhere some guidelines, some rules and regulations that are essential, imperative for the drafting. Now drafting is of two types. Legal drafting is of two types, basically pleading and conveyancing. What exactly is pleading? Pleading means when there are two parties in the court. Obviously there are two parties in the court. So one is plaintiff and other is defendant in a civil suit. One is asking in favor of it and other is defending in favor against it. So when there are two parties in the presence of the court, they are fighting for the case, right? So that amounts to pleading, right? Now what exactly is conveyancing? Conveyancing means when you are fighting for the legal rights. The legal rights are restored in the property and you want to challenge them. You want to challenge them for the rights that are inherent in the property, that are vested in the property. So when the rights are pertaining to property, that amounts to conveyancing. And when you are fighting the case for the civil action in the court, in the premises of the court, that is known as pleading. So having understood what is exactly drafting, and the legal drafting is of two types. Now we move on ahead. Now what are the basic essentials that we need to keep in our mind? So some basic points, some rules. First, there must be a design in our mind. First essential is design. A picture should be formulated in our mind that would take us to the end, that would take us to a good consequence, right? Next is we need to note down all the points. There should be a systematic presentation. So for the systematic presentation, whatever thought that comes to our mind, we need to write down on a given piece of paper, and then we will relate it, connect it at the end, right? Then there should be active voice used. Active voice should be preferred in comparison to passive voice, because active voice tells us who would be performing the task. So it comparatively becomes very easy. So we need to prefer to active voice, right? Then the language should be simple and clear. if the language is ambiguous, if the language is very difficult, if the language is very people are not able to understand, people are not able to comprehend, then it becomes very difficult. So the language should be simple and easy for the people to understand, right? Then next comes that the design I have already told. Then double meaning should not be used. The words that refer to double meaning, that have two meanings at the same time, simultaneously one word has two meanings, they should be avoided, right? Then the next essential is brief. The brief should be, whatever the draft we are preparing, the brief that is known as brief, it should be concise, point wise and systematic and clear. So all these essentials contemplate a good drafting that we need to keep in mind, right? Now, having understood this, what basically our focus is, that we need to understand what is exactly notice. So notice, this video is primarily focusing upon notice, how to prepare the legal notice. What exactly do you mean by notice? Notice means a warning that is given to the other party, that if you are not adhering with the legal conditions, the conditions that are stipulated, if you violate, if you go against the such conditions, then penalty would be imposed, strict action would be taken against you, right? So this refers to notice. Now notice are of three types. Notice are of three types: notice proper, then notice reply and rejoinder, right? So three types of notice are there. What exactly is notice proper? Notice proper basically refers to the first time notice. When a notice is issued for the first time to the party, that is known as notice proper, right? Then what exactly is notice reply? When the notice is served from one party to the other and he has to make the reply in adherence to the same, so this is known as notice reply, when we need to reply for the notice that we have received, right? Then what exactly is rejoinder? Rejoinder is nothing but the reply of the notice reply. See, the reply of the notice reply is basically rejoinder. It also said written statement. In CPC there is a term that is known as written statement, is basically rejoinder. When you are giving an answer to the answer, that is known as rejoinder. So having understood what is notice and what are the types of notice, now we take some examples where notice are issued. Now notice are issued in various places in our day-to-day life, like for an example in consumer courts. Whenever we purchase some goods online or offline and that good is not in a proper condition, so we need to return it back. And if the if the seller is not taking it back, then we can file a consumer notice, right? To rectify the mistakes, to rectify the deficiencies involved, we are issuing consumer notice to the seller of the goods, right? Then sometimes in possession cases we file the legal notice, like for eviction of the tenant, or there is some misuse in taking rent related matters, so or possession related matters, there are sometimes legal notice pointed out, right? Then in SURFACI Act, for debt recovery matters, there are legal issued notices. Then in negotiable instrument that we will be dealing today, for dishonor of check, if a check is dishonored, then we issue legal notice, right? Then sometime for money recovery, for recovery of money, we issue legal notice. Also for the recovery of salary, sometimes the employer does not give the required salary to the employee. So in such cases, employee has a right to file a legal notice against such employer, right? So having understood the instances, the examples that require legal notice in our day-to-day lives, so now moving ahead, we'll understand how can we draft the legal notice in a given circumstances. So I have formulated 3 particular drafts that will help you in drafting a lot. This particular video would help you in practice in litigation a lot, as well as your judicial exams, right? Framing of issues in CPC, it would help, right? So first, my formulation would be regarding eviction. When you want to issue a notice for the tenancy, for the eviction of rent, or tenancy or possession related matters, property related matters, right? So here it is. First we need to write our name. What is our name? Then what are our qualifications? Then advocate. These 3 steps would be written here, and then on the right side our address, then our contact number and our email, right? So this is basic guidelines that we need to adhere. Then we'll write in the middle, notice registered AD, acknowledgement to you, right? And one thing we must keep in mind, that we will never write in abbreviations. We'll always write in full sentences, right? Simple and clear. Then we'll write to Shri A, B and C, whatever the persons are, who the persons are, then their address, then sir, then comma, as per the instructions of my client, because we are representing our client. So as per instructions of my client, as per information received by my client, I address you as following. I want to address you as following. I have some issues in my mind, so I want to address you as following. Now the points are there. We will write in points and not in paragraphs. That you must keep in mind. And also we must keep in mind that we'll write with that. The word that will be used. That the person whose property was it, the owner has died, and now the legal heirs are his son and wife, right? So the main person has died, the owner has died, and now the property will shift to their legal heirs, that is their sons and their wife. And you, the person against whom we are claiming, you are a tenant in our property since 2000. We can write any year. You are a tenant in our property, right? And you were giving regular payment. Regular payment was given by you up till 2001. We can take any year. That you were very fine, your behavior was very fine, your conduct was very good, and you were regularly paying the payment. No problem was there. The issue arises when we asked for the payment after 2001 and you refused. After the repeated oral demands were made and you refused straight away, right? So we came with the legal notice, right? Then 5th point, we can write that there are some areas regarding the rent and the increase of rent you might need to pay, right? And time, we can state that within 1 month you must pay the amount. Then at the end we can write that your please vacate our premises and terminate the tenancy involved and hand over the possession. Whatever possession you have, please hand over to us, back to us. And if you fail whatever we are directing, and if you fail regarding such conditions, then legal action would be taken against you. And since we are issuing a legal notice to you, so a cost of notice is posted upon you, that is rupees 1000. And at the end we can write yours faithfully, Advocate Drishti, whatever our name is, and then in the bracket advocate. So this is the format of how to issue a legal notice regarding the possession, eviction of rent, or regarding the property, right? Hope you have understood. Now we need to understand the second form of notice, that is regarding section 138. Now what exactly is section 138? 138 of negotiable instrument talks about, states the dishonor of check. When there is insufficiency of funds, then criminal or civil liabilities imposed on us, and whenever such liability is imposed on us, we are penalized for the same, right? So that is section 138. Some time periods are given that we need to understand, like within a period of 15 days we must pay the amount. Then later on, within a span of 30 days we need to comply with the guidelines, and if we fail to comply with the guidelines, stipulated guidelines, then legal action would be taken against us. So what is the draft? What is the actual draft? How we can prepare? See, the format remains the same. First we'll write our name, then qualification, and then advocate, then address, then contact and email, right? This remains fixed, right? Standard. Then notice, registered AD, acknowledgement due, right? Then we'll frame some guidelines. उससे पहले to Shri whatever the persons are, whoever the persons are, address, sir, as per the information of my client, because we are receiving the information, I address you as following. We have some issues that we need to resolve. So the first point becomes that we'll use the word that before every sentence, and we'll write in points that we were old friends. We were old friends and there was a good relationship between you and us, right? Then we'll introduce ourselves that we had a good business and we have a long business that was from years long, right? And you have just started, so we became friends because the business was of same kind, same nature. I was also doing the business of cloth and you was also doing the business of cloth, and we became friends. So there was a dealing, purchasing and selling was done. So you were when we bought some items from you, when we bought some goods from you, you were paying the amount very regularly and frequently through checks. But suddenly, after a period of time over the years, you made a payment through the check and we presented in court, presented in bank, right? Sorry. When we presented your check in the bank refused to collect it, right? The bank refused to admit it and the bank returned it. So the bank returned it because of insufficiency of funds. The bank strictly said that there is insufficiency of funds, and if there is insufficiency of funds, then you would be criminally and civil liable. You would be liable for strict action would be taken against you, civil as well as criminal, right? So you can refer to CPC Civil Procedure Code as well as section 138 of Negotiable Instrument Act, right? Then a strict warning, a last warning is given, since you were my friend, that you can pay you can pay the payment, you can make the payment within a span of 15 days, right? And if you still fail to adhere with the regulations that are imposed in this legal notice, then legal action would be taken against you, and a cost of 1500 as a notice, because we are issuing a notice, so 1500 cost is imposed on you, right? So having understood this, now the third type of notice. Hope it is clear. If any doubts, you can ask me in comments. Now if we are issuing sometimes there is a situation that we are issuing a notice to the government. We can issue a notice to the government as well. Some people must be surprised that how we can issue a notice to the government. Yes, we can issue notice to the government as well as, but the procedure is a little different. Here we need to understand section 80 of Civil Procedure Code (CPC) that clearly stipulates that a notice before the 2 months should be given to the authority concerned, right? Now what is the object behind that? What is basically the rationale behind that? The basic rationale is that he can check the veracity of the statement, and he can rectify his mistake without going to the court and without expanding its money. Without making expense, he can resolve the matter outside the court, right? For the speedy disposal of matter, 2 months time is given to the government authority, right? So here the format remains the same: name, qualification, then address, then here advocate, then here address, then here contact, email, notice, registered notice, then the format changes. Here we are issuing to the authority, right? So here we'll write to the principal secretary because he the authority. Then we'll write his address. Collector will write his address. Tehsildar will write his address, right? And then we'll start our issues. What are our fact and issues? First we can write that my client resides in such and such premises. We'll write the address and my client resides in such and such place. Then he had an ancestral property from a long time. He had an ancestral property from a past 25 years. He was living in the same property, right? That this property was subject to renovation. Some part was given for construction. That doesn't mean that property has stopped as an ancestral property, because the property was too old, too ancient, so some repairs need to be done, right? But to my surprise, then we'll write to my surprise, I am very dazzled, I am very amazed, I am very astonished that some notice was issued to me that the construction was illegal, right? And the government officials wanted to take over our property. Why? My property was ancient and I never did any illegal work, so why should my property be taken over, right? So we'll write in the 5th point that my property is not illegal and we have never done any illegal work. Then we'll write that strict action should be taken against you, and we direct you for injunction that the work should be stopped then and there, and declaration that it is not our property, it is our ancestral property, right? Then we'll write particulars of the plaintiff, defendant, name, address, and the cause in issue and form, right? And then the relief, that is a civil case, and whatever relief we want. And then time period, we'll mention that within a span of this much 60 days, please vacate this and do not say that a property is illegal and hand over our property back to us, because it is not illegal. And a cost of 5,000 is imposed on you. And then we'll write yours faithfully, Advocate Drishti, and at the end, advocate. So these were the 3 formats, that different types of format, distinct type of format that I used for drafting the legal notice to the tenant, to dishonor of check, for the dishonor of the check, or to the government officials, right? So I hope I am able to clear with the drafting of the legal notice. Meet you in next video with new interesting facts. Hope you liked the video, and thank you so much for watching this video so patiently and so happily. Bye bye, take care. Meet you in next video with new interesting facts. Till then, bye bye, take care.